Hey everybody, thanks for joining me once again for another edition of Will Wednesdays. I'm your host, Greg Davis with Tri-City Lawyers here in Durham, North Carolina. This week's topic is, Greg, you've been talking about wills and will packages and trust, but how do I get one? This week's topic is the will package 7-step process. This is the process that I use here in Durham at Tri-City Lawyers. But first, a brief disclaimer. The information provided in this presentation is not intended to constitute legal advice. Instead, all information, content, materials presented are for general informational purposes only. Viewers of this presentation should contact their attorney to obtain advice with respect to any particular legal matter. No reader, user, or browser of this presentation should act or refrain from acting on the basis of information in this presentation without first seeking legal advice from counsel in the relevant jurisdiction. Step number 1. I'm going to ask you to please provide me with any existing estate planning documents. If you already have a will, you already have a trust, you already have a healthcare general power of attorney, please send that my way. That'll help me get my process rolling. If you don't, nothing wrong with that. We'll just go on to step number 2. And step number 2 is I'm going to ask you to please fill out a client questionnaire. Now, a lot of people say, oh, Craig, I started this process before somebody else, and they asked me all these questions, and I had all these forms to fill out, and it took so long. And I understand that. So my form is relatively short. It's only 4 pages. And this is the question I get. Well, Greg, do I need to give you my account information and my account balances? Well, generally the answer is no. I'm never going to need your account information. Why I do ask for your assets and liabilities is because I want to know if you're going to have any estate tax or income tax planning issues that we should address in your documents. But once again, you can always just provide as much or as little information as you choose. The third step in this process is an engagement letter. This is where I write down everything that we've discussed in terms of the services I'm going to provide, the will, general power of attorney, healthcare power of attorney, and your living will, and whether or not we're going to do a trust, and then how I arrived at my fees. Okay, and that's all going to be an engagement letter. I send that to you. You sign it with a wet signature and send that back, and we keep going. Step number 4, I'm probably going to ask for additional information. For example, let's talk about who exactly is going to be your executor. Who do you want to be your agent for your general power of attorney, your health care power of attorney? Have you thought about whether or not you want to have a natural death? Step number 5, that's it. That's all I need, because now I'm going to start drafting your documents. And this is the really fun part for me, because everything that we've talked about is now getting put to paper. And I always tell my clients, I like to work as fast as you work. So if you want this to take a week, it can take a week. If you want it to take a month, it can take a month. But it really shouldn't take a month, because if we're going back and forth like we should get it done relatively quickly. Step number 6, revisions and approval. I'm going to ask you to look at the documents that I drafted and say, print it out, get a pen, read it out loud. Does it make sense? Do you feel comfortable? Do you want to make any changes? And if you do want to make any changes, I'll make those changes for you. And then that brings us to step number 7, signing day. This is it. And I didn't tell you, we have to have a goal. So way back in step number 2, when I have you fill out that client questionnaire, the first question I ask is, what is our target signing date? That target signing date from the very beginning gives us a goal. So if today is September 1 and you tell me you want to close this out by October 1, I'm going to make sure I work with you, even if I have to push you to make sure that we get all the information we need to get your documents complete. That's it. That's my 7-step process. If you have any questions, please feel free to reach out to me. This is Greg Davis with Tri-City Lawyers here in Durham, North Carolina. And like I always like to say, everyone has an estate, but not everyone has a plan. Any questions?
Hi, Greg.
Hey.
Yeah, thanks so much for the presentation. So I do have asked. So I guess, and this is in no particular order, but you said something about an executor, and I've always heard about that. How do I, who do I pick as an executor? I'm not, how do I go about that?
Yeah, very important decision. If you're married, most people will choose their spouse to be the executor. Now, that should not necessarily be the default, it should go with some consideration, because being an executor carries a lot of responsibility in terms of having to file documents, in terms of having to make distributions from the will, and assuming there is a will. And so that can put a lot of pressure on that person who might be grieving at that time. So in some cases, you don't want your spouse to be the executor. So it really depends on whether or not you think your spouse is going to be able to manage that burden at that time. Generally speaking, who do you want to be your executor? You probably want to look for somebody that has some kind of business sense. Maybe they're good with numbers, or at the least, you want somebody that's a people person, or somebody that knows how to bring people together. Because sometimes when it comes to making distributions of final assets, people can get a little upset, especially if things aren't laid out clearly in the will. So definitely being somebody that understands business and is a peacemaker are some good qualities to think about.
Okay, so you just made me think of another question.
Yeah.
You said the executor could be my spouse. So does that mean my spouse, that we each have to have our own individual package?
Yes. So when you write a will, it's going to be one just for Glenn, and then one for your spouse or significant other. I'm married, so I'm going to have my own last will and testament for Greg Davis, and then my wife is going to have her own last will and testament. Now, that might lead to the natural question of, well, does the executor have to be the same? And no, it does not. It does not have to be the same.
Oh, Greg, if we go through this whole process,
yeah,
and I don't know, say it takes a month or two, we find out we have our target date as you talked about. Like, then what? Is that permanent now, or do I never have to go through this process again?
Yeah, good question. So a will is not necessarily something you should do and just put away forever. It's something that you definitely want to update or at least revisit once a year, because things change. The person that you named as an executor, or maybe even as a beneficiary, maybe that person passed away, and so you need to keep that will updated.
And what about, I guess, some of the other roles we talked about? There's the executor, the power of attorney. Like, do all of those have to be the same person, or can they be different?
They don't have to be the same person. So for example, the executor, that person is not going to take any action until you pass away, because the will doesn't take effect until you pass away. Now, for the general power of attorney versus the healthcare power of attorney, now, generally speaking, if somebody is married, then the executor, the primary agent for the general power of attorney, and the primary agent for the healthcare power of attorney, they're all going to be the same person, generally speaking. But there could be a situation where, once again, you don't want to put your spouse in a position to manage the finances. So maybe you have the spouse as the executor, but you name someone else as the general power of attorney to manage the finances. Same thing might go for the healthcare power of attorney. That could be your spouse, or it could be someone else that you think is better suited to make those healthcare decisions at that time.
Like, I don't know, my spouse might want to manage money.
Yeah, I understand, but I've met couples where there's real estate and there's a business, and the couple's retired, and so neither couple really has as much of a strong handle on the day-to-day activities as they used to. And so they, in that scenario, they didn't want the spouse to be the primary agent. They wanted the son, who, he's a little bit more business savvy. He's a little more on the ground. So they made him the primary agent. So each scenario and each family situation is different.
Greg, just, hypothetically speaking, if I don't have that much, like, do I really need to go through all of this?
You know, a lot of people think that, I have to have this big amount of money to have a will and have a trust. And that's why I always say, everybody has an estate, because whether you know it or not, everyone has an estate. If you die and you die without a will, because that's called dying intestate, fancy word. This means dying without a will. Those assets have to go through probate. Now with the will, it's still going to go through probate, but at least with the will in place, what it does is it clarifies how you want your assets to be distributed. It clarifies how any remaining taxes should be paid. If you have children, it clarifies who you want to be the guardian of your children. So it's essential to have these documents in place. I spoke with a gentleman who just went down to Florida to handle his mom's estate. She passed away. She had everything in a trust. And he said, I wish that, she had a will, she had a trust, but he said what she didn't have was a list of tangible property. So for example, there's a fancy dining room table, there's some jewelry. She never said who she wants to get those assets. And in this family, there's 5 siblings. So he's like, man, now we have a little bit of a headache because it wasn't clear how I want these assets to be distributed. So having a will, having a memorandum listed on your tangible property, who should get what, it's essential. It just makes things so much easier for the people who are left behind. I got another call just this week, and this woman, she sounded pretty young. And she said, I want to set up a living will and a trust. And I said, just out of curiosity, you sound pretty young. Well, why do you want to do that? And she said, a family member of mine just passed away 8 months ago, and we're still going through probate. So she said, it's awful, and I want to make it easier for those that I leave behind. And I said, that's the message right there. That's it right there.